Good morning, everyone. Welcome to another cafe webinar. This is a 20-minute refresher about shareholder agreements. And if you're a bit late or you have to move on quickly after being sitting with us for just a few minutes, it will be recorded. And so we'll distribute it out to everyone who has registered for this webinar. Now, last year we formed the Brainstorm Room. We got together a bright group of people to help business owners get through COVID lockdown and answer some of their pressing questions. This year we've morphed into the Brainstorm Cafe. So now we're going to have regular 20-minute webinars on hot business topics and subjects, bringing in experts to be able to talk about them. Now, Hamish is one of those experts that's going to talk about shareholder agreements. And just a little bit about the Brainstorm Cafe. Go to our website, and if you're not already a member, register, become a member. If you've got a business problem that you want solving, or you want just a lateral viewpoint on it, fill in your name and address, give us an overview of your problem, and one of our experts will contact you. And that's a free service until you formally engage that professional, no cost to you. So Hamish Douch is here to talk about shareholder agreements today. Last year he did a long webinar. It was a bit of a blockbuster. We had hundreds and hundreds of people registered for that, and because it's a hot topic. And if you've got more than two shareholders or more in a business or a company, you should look at having a shareholders agreement. It's an absolute must. So at the end of the webinar, we'll be answering the questions that come in. So if you've got a specific question during this webinar, just type it in. You'll see in the chat session on the right-hand side of your screen, you can type anything in there. If we don't get to answer it today, you will get an answer because we've got your contact details, and we'll follow up with an email within a day or two. So don't worry if you don't hear from us today, because we want to keep it to 20 minutes, short, sharp, while you're having a coffee, which reminds me, I just had my coffee delivered. And this is what it's all about. You take 20 minutes out of your day to have a coffee, and you hear an expert talk about a good subject. So Hamish, over to you. I'll shut up now. Your audience is waiting, Hamish.
Great, thanks for that, Jamie. I also have got a coffee, which is great. So thank you very much for that. I think this is a great format for doing these things where we are short and sharp and get into it. So look, I've been asked a bit of a refresher on shareholder agreements. It's something that I feel are necessary for all companies, as Jamie said, with two or more people. People often ask me, do I need a shareholders agreement? What is a shareholders agreement? What should go into it? And look, I could talk for hours, as Jamie may have mentioned earlier, on this. It's something I'm quite passionate about and something I believe is necessary for pretty much most companies. A shareholders agreement is a document between the shareholders. That's why it's called a shareholders agreement. It generally deals the way in which you as the shareholders operate as shareholders in the company. So that is a bit of a mouthful, I do appreciate, but the idea is that it sets the ground rules for how you as shareholders will work together. One of the things I'm often asked is, do I need if it's husband and wife? And Jamie and I were just talking about this earlier. I do believe it is. I often say to people when they come in to talk to me about a shareholders agreement, that this is your opportunity to get all your cards on the table and have a discussion as to how you want to work together. So whether this is a husband or wife, whether this is a couple of mates who've got an idea. I was talking to a friend at the weekend who's setting up a gin factory or gin distillery with a few mates as well. So it is something where you all need to get together. Now, for example, I'll use that gin distillery as an example. One of the people involved had all the ideas of how to run a distillery. He knew how to make gin, had been making it in his garage for a number of years, and they wanted to set up a company to actually make gin. What he had, however, was not really the financial backing to enable him to do it. So what he'd done is he'd approached a couple of people, and they'd gone and bought a building together, and they were then going to operate together to run a distillery. So two of them were introducing capital. One of them was also a marketer, and one of them was a gin distiller. So between the three of them, they set out the rules for how they're going to operate, and just as importantly, what each of them would do in the company, i.e. the distiller would be employed by the company, the marketer would do some marketing for the company, and the third person would probably drink the gin and enjoy it and help with the general business ideas of how they should manage and run their company. Now, if they don't have an agreement, they could run into difficulties as to how they will do this, i.e. will the distiller say to the person with the money, well, I'm actually making this gin, therefore I should get a larger share of the dividends or the profits. A shareholders agreement will set out what each person needs to do and how they do it. i.e. the distiller will get paid a salary, which will probably be market. The marketer will be employed by the company to do the marketing, and the money man may just sit there as a director and a shareholder. However, it will cover things such as the money that goes into the company and how that is returned to the individual shareholders, whether it is dividends, whether it is salaries, etc. Another thing that's quite important when you're looking at those, and I'm still using this example, is that what are you going to do with the profits of the company? Does one of you say, I actually want to plow everything back into this company for 5 years? We'll market the company, we'll go, well, we'll be bought out, we'll take our money out when we get taken over by someone else, and or when we're producing X thousand bottles of gin a week. Does one of you say, oh, look, I'm not really keen on that idea. I've got to pay the mortgage on my house, so therefore I need X per week. So those are some very, very broad outlines as to what must go into it, i.e. how you will operate together. A shareholders agreement is a private document. It is not publicly searchable. A constitution is a publicly searchable document, and many companies will have a constitution. That will often, the constitution, deal with things like meetings, how you will issue shares, etc. But the shareholders agreement will go into that further detail. You don't necessarily want everyone to see. Jamie mentioned there 2 or more people in a company and potentially a husband and wife type situation. That is a very key role to have a shareholders agreement for a company with only a husband or wife or partners. And the reason for that is it's kind of the what if scenario. So what if the worst would happen and the relationship would end? How do you deal with the company? What if one of you suffers disablement? How do you deal with the company? It's almost as crucial for a husband and wife as it is for, or sorry, I should say to a partnership, than it is for a widely ranging company, because it is that key document that ties you all together. Some of the other things you may put in it, and I often get asked this, is I've been asked as a director to provide a guarantee. The other directors haven't been asked to provide a guarantee, and I'm assuming here that all the directors are the shareholders as well. Now, you may be unequal shareholders, but you may also be directors. And often this is the case where, say, one of you is working in the business, and you're seen to be working in the business, and or you're seen to be the person with the money. How do you deal with a guarantee? So one of the key items in a shareholders agreement is to, for example, say that even if person A has to provide a guarantee, if that guarantee is called upon, they are indemnified, i.e. that means the other shareholders will pay monies to that person relevant to your shareholding. So if the director is a 25% shareholder and the guarantee is called upon and it costs $100,000, the other shareholders who make up 75% of the company will contribute to the person who's called upon for the guarantee for that $75,000. I'm just going to sip my coffee here, actually, since we're in a cafe. I often get asked, how do you bring another person on, and what if we can't agree to bring that person on? So you'll often cover off something called preemptive rights, which says that if you want to bring another person into the company, or someone wants to sell their shares, they must first offer their shares to the existing shareholders. And the theory behind that is that you have got together with your 2 mates, with your wife, with your husband, with your partner, with 5 schoolmates, whatever it may be, to establish this company. And you've done that because you've either got some certain skills that you all bring to the table, and or you've all got ideas that you want to run together, because one of you's got a business product that needs some money from others to run and to scale up. You have picked the people or the people have picked each other that you're in business with, that you're in this company with. What you don't want to necessarily get is someone who one or more of you doesn't agree with becoming a shareholder in that company. That could be a competitor, that could be your worst enemy at school, that could be your brother-in-law who you don't get on with. I hasten to add I do get on well with all my brothers-in-law. But that's the sort of scenario where you want to ensure that you have control over who else could become a shareholder in the company. So the preemptive rights say that if person A wants to sell their shares to an outsider, the other shareholders have the right to match the offer to that outsider and can come in and take over the shares of person A, such the outsider is not brought into the company. Tied into that are often what we call drag-along and tag-along rights. So that if someone did want to sell their shares, for example, I'll go back to my distilling friend. They received an offer, for example, and I'm sure they'll be thrilled if they got this, to sell their company for millions of dollars because it is the latest, greatest, best thing in gins. Two of them want to accept it. The third one goes, I'm not really sure. A drag-along says that once a certain percentage of the shareholders wish to sell their shares, they can drag along the other shareholder or shareholders to also sell their shares on the same terms and conditions. This means there is control with whether it's a simple majority, whether it's 75%, 80%, 90%, whatever figure you wish to choose, can get those people to come along with them, can drag them along. Similar to this, but slightly different, is something called a tag-along. So when a certain shareholder wishes to sell their shares and their preemptive rights are not given effect to, i.e. the other shareholders don't buy their shares, and they wish to sell to an outsider, the other shareholders can tag along, i.e. can say, you can only sell your shares to this person if I'm also allowed to sell my shares to that person on the same terms and conditions. Those are the sort of things that are slightly more technical, but you do need to have in your agreement to ensure that you do try and cover all eventualities. What else? Oh, I was going to talk about quickly about buy-sell. People often ask me, is a buy-sell agreement part of a shareholders agreement? A buy-sell agreement is in relation to what happens if one of the shareholders can no longer work in the company, or even if they don't work in the company, if that shareholder dies or suffers a permanent total disablement, and you want the ability to buy that person's shares. What a buy-sell agreement covers is the insurance that you have over that person's, whether it's life and or health, or just one or the other, and says that if that person suffers either death or a total permanent disablement, there is a payout of monies from an insurance company to a third party who holds that money and then utilises it to buy the shares of the person who suffered either the disablement or who has passed away. And the money that they receive from the insurance policy is utilised to purchase those shares. The great advantage of this is, and this is what I say to people, and when they actually think about it, they go, oh, yes, is do you want to be in business with your business partner's widow's husband's new lawyer? And I know that's sort of drawing a long bow, but that's the sort of thing that can end up happening when you do not have the ability to purchase shares on certain events happening. I'm just going to have another sip of my coffee here. Jamie, were there any questions at this stage?
I have a question that's come in. My mic working? A question that's come in. From the get-go, you've got 3 or 4 or 5 people coming together, and you all sit around nodding your head and say, yeah, we should have a shareholders agreement. Who takes the initiative? If the company has a lawyer already, and the 4 or 5 shareholders, do they need independent representation? Who sort of takes it first and say, let's nominate one person to get on and do the overall draft? Is that how you start one? And then what happens after that?
Yeah, look, that's generally the way that you will have a lawyer for the company. And or if you don't have a lawyer for the company already, or you feel the lawyer for the company perhaps is not skilled in that, you can go to an external person who knows and deals with a lot of shareholders agreement, and say to them, can you put together an agreement? That lawyer needs to be aware that if they act for any of the individuals, that they have to be conscious that they are acting in this instance, for all the shareholders together and generally the company to put together the shareholders agreement. So the shareholders agreement must be fair and it must take into account everyone's views. So you can get a difficulty when you get a number of different people with all disparate views, and how do you tie them all together? But unfortunately, that's just the role that as lawyers that you have. So going back to your question, Jamie, yes, you would either get the lawyer or an external lawyer to meet, whether that be virtually or in real life. So I'm using a term here from my son, IRL, which is something that's new to me. You would meet and you would come up with your suggestions, recommendations, and put forward the agreement. Often then people want their own lawyer to look at it from their particular point of view. And that at times can be a very useful second step that is taken, because they may be aware of circumstances of a particular individual that may say that that person needs to put some recommendations forward to amend the agreement. Does that answer your question, Jamie?
Yeah, pretty well. Another one, full disclosure. When we take out health insurance or life insurance or whatever, now we have to go through so much more paraphernalia or answer more and more difficult questions, so that it's total and full exposure or disclosure. Is that the type of thing that now should be baked into a shareholders agreement?
Yeah, you'll generally have a clause just and faithful to one another in your agreement, such that you are disclosing anything that would be relevant to that. So, for example, if you were suffering an illness and you're going into a business with someone, I think you'd want to disclose that. The insurance is a very high hurdle to get over, obviously, as you just mentioned, about disclosure of everything. Look, I'm not an insurance lawyer, so I'm not going to try and give advice on your obligations to disclose, but insurance has shown us that at times they would like to be very aware of all the circumstances and may not pay out if they're not aware of all the circumstances, which is very reasonable. You have entered into a contract with this company or individual to do certain things. So the disclosure is important within the insurance and also within the shareholders agreement as to what you're going to do. So, for example, if you are going to be competing with the company, and this isn't strictly tied into your health question, Jamie, but if you're going to be competing with the company, so for example, I'll go back to my gin distiller. There's a gin distiller, but you also have an interest in a bottling company, for example, or you have an interest in a pub, for example. You probably want to disclose that, and you would want to disclose that, would want that to be recorded, such that at a later date, you aren't deemed to be in breach of the shareholders agreement by virtue of your so-called competitive business. So you do need to have that in there, and it is quite important, what is very important to have that. This agreement should be in utmost good faith between you. Just one other thing on the disclosure requirements, Jamie. You mentioned you have to disclose things. Now, for example, if you were a skydiver, that was your hobby, for example, you may find that there is a exclusion on any life policy or TPD policy you get if your injury is suffered whilst you are skydiving. So often what you'll have is a carve out in your buy-sell or your shareholders agreement that if you suffer death or disablement whilst doing that carve out, that in fact your shares won't be purchased at full value, and or if the insurance doesn't respond, you may not get any value for your shares, or otherwise a limited value, or there'll be some other mechanism for working out what you should be paid. Because of course, the point of the insurance is to ensure that there is a payout so that the remaining shareholders do have monies to purchase. And if through an exclusion that you've got on your policy, the insurance doesn't respond, is that fair that the remaining shareholders have to put their hands in their pockets to stump up the monies to buy your shares?
Right, and we're just about out of time, but we'll run a few minutes over just to cover a couple more questions. Hamish, often there's a reluctance. I've been consulting to many companies for many years, and often you get 2 or 3 shareholders who want to move forward, but there'll be one that holds back. Either they think it's expensive or they think they don't really need one. How do you overcome in an existing company a little bit of reluctance for someone to get engaged and involved? They may be a shareholder, but they're holding back. How how do you overcome that sort of procrastination or reluctance? Is that a question for a lawyer?
Well, isn't that a question for a psychologist?
All right, okay.
Yeah.
Well, we'll get one of those next week.
Yeah, look, it's a difficult question, Jamie. Look, I think it's a very valid point you make. I have a couple of war stories which I don't like to tell people, but for example, I did have a client that's going back quite a few years who the business wasn't going that well, and they were on the ground. They had shareholders who weren't here, they were in another city, and my client put quite a bit of money into the company to try and keep the company going to pay certain things. There was no shareholders agreement. Therefore, there was no requirement or agreement between the shareholders. The one puts in money, that either the other must put in the same amount of money, and or if they don't put in money, that there is a debt owed back to the person who's put in the money. The company eventually went under, and the client that I was acting for, I didn't act for the company, I hastened to add, acted for an individual. The client I was acting for, who only came to me when all this had occurred, had a current account with the company. They were owed, I think it was a couple of $100,000 from the company. The company was liquidated, assets were sold, nothing to pay out the shareholders, nothing to pay out the current account. So that my client lost out on all that money they put into the company. They had a shareholders agreement which said that if one needs to put in money and the other matches it, or the other will reimburse if required, then we would have had an ability to go to that other shareholder and say, right, my client's put in 200,000, you're a 75% shareholder, you need to pay my client $150,000.
Hamish, last question. And I believe we're having some sound problems, so apologies for everyone who's joined and haven't quite got the full sound. There will be a replay and we will be distributing that. So sorry about that. It's just we didn't quite get a couple of things right that we're trying today. Last question. The relationship between directors and shareholders. The shareholders obviously are not always directors. In a shareholders agreement, what sort of powers, if any, should there be, and how should it be apportioned for a shareholder to appoint a director of a company? Should that be covered in the shareholders agreements?
Yeah, look, generally speaking, directors get appointed by a majority of the shareholders who vote, and they get appointed. But often what you'll reserve in a shareholders agreement is if you are a shareholder to a certain level, you get the right to appoint one or more directors, i.e., let's say you've got a company with a 50% shareholder and two 25% shareholders. You might say we're going to have 5 directors or 3 directors or whatever that number is, and you'll reserve the right. So the 50% shareholder may get the right to appoint a director at all times and always make that decision. And the other shareholders may need to appoint the other 2 directors between them. Or you may have an ability whereby it's just done straight by majority. But of course, in that case, with a 50, 25, 25, you're difficult to get a majority because you need the 50 and one of the 25s to agree. But simply speaking, yes, I believe you should cover that in a shareholders agreement as to how directors are appointed, who gets to appoint them, whether certain keystone shareholders have the absolute right to appoint directors. You also need to cover whether or not those directors are able to act in the best interest of the shareholder or must act in the best interest of the company.
Hamish, we've come to the end of our time. Really appreciate your time today. Again, apologies. Apparently there's been some sound issues. It hasn't happened to us before. We've had a lot of webinars over the last year, so we'll find out what the cause of that is. Hamish, thank you very much for coming today. If you've got any queries or questions, send them to Jamie at e3businessaccountants.co.nz and or call me on 0274 337 280. So thank you very much again, Hamish. And,
thanks, Jamie.
And we'll be back. Thank you.